and welcome you back. Time to take your seats again so that we can get started. So I now have the pleasure of introducing to you our next speaker, Malika Saar. She is Google's Senior Counsel on Civil and Human Rights. And before joining Google, she was the founder and executive director of the Human Rights Project for Girls, Rights for Girls, a human rights organization focused on gender-based violence against young women and girls in the United States. She also served as special counsel on human rights at the Rabin Group. As a human rights lawyer and advocate, Saar led the effort to shut down Craigslist sex ads that served as the leading site for the trafficking of children for sex, ended the federal practice of shackling pregnant mothers behind bars in U.S. prisons, and successfully advocated for millions in federal funding for treatment services for at-risk families. Newsweek and Daily Beast have named her as one of the 150 women who shake the world. The Obama White House selected her to serve on the Presidential Advisory Council on HIV/AIDS. She also serves on the board of directors for the Robert F. Kennedy Center for Human Rights and the SE Justice Group, and has been featured in numerous media publications, radio, and TV shows. So please welcome Malika Saar.
Good morning. It's good to be here with you today. I'm going to unapologetically center my conversation with you around the experiences of Black and brown girls in the United States. And I want to begin that conversation with the story of Reese Taylor. In 1944, Reese Taylor was an African-American woman in Alabama. She was a mother of a 6-month-old baby. She was a wife, and she wanted to go to church because it had been a while since she was able to go with her baby. And on her way back from church, she was raped by 6 white men. And Reese Taylor, with the support of the Black press at the time and civil rights defenders like Rosa Parks, decided to actually do what was unthinkable and hold those men accountable for their rape of her. She, with the support of the Black press and the civil rights community, tried to hold them legally accountable in a court of law for their rape. Their defense was that she was unrapeable because she was a prostitute. And because she was a Black woman in the South in 1944, it was accepted that, in fact, she must have been a prostitute in some way by virtue of her being female and Black. She was, in fact, unrapeable. And the 6 men were allowed to go free. I strongly believe that although Reese Taylor's story is a story of the past, it is also very present in the way that we talk about Black and brown girls who are coerced into being bought and sold. There is still very much a notion in this country that Black and brown girls are unrapeable. It is a historically entrenched narrative that reaches beyond the time of Reese Taylor, that Black and brown women and girls have always been seen and framed as over-sexualized, as the Jezebel, as the sapphire, as the whore. And as such, the sexual violence done to them is never recognized as violence, but as an act that has been chosen by them because of their over-sexualization, because they are unrapeable. In the way that we talk about girls in this country who are disproportionately black and brown, who are girls, we rarely see them framed, understood, legally construed as a victim or survivor of sexual violence. Instead, the girls who are bought and sold are described so often as child prostitutes, are treated so often as criminals and arrested for the act of prostitution, even though they are not of age to consent. And so in that way of describing the girls who are disproportionately black and brown, the girls who are put into these situations of being bought and sold, describing them as child prostitutes, criminalizing them for the act of prostitution, is an extension of this narrative of unrapeability. That we do not understand that what they have been subject to is commercial serial rape, for which they should be given services and be legally protected as child victims of rape. Instead, they are named and too often legally construed as at fault, as prostitute, as criminal. And I think in that narrative and legal treatment is not only the historical denial of victim of sexual violence, that status, that experience of victim of sexual violence that is rarely allowed, rarely given to black and brown girls. It is an extension of that. But it's also an extension of how we deny the status of child to so many black and brown girls. And we've seen this play out in terms of black men and boys in this country. So that when black boys become older, like at the age of 12, the black male body is perceived as weaponized. And as such, a Tamir Rice can be killed by the police with impunity. Because so often, the narrative is that the black male body is a form of weapon by virtue of its maleness and its blackness, and therefore is denied child status, right? So Tamir Rice is not seen as a child. He is seen and treated and killed because of an identity of adult, of dangerous. And the same is true here around the denial of the child status that is given or denied to our girls of color. So often when we talk about this issue, it's fascinating to me that we don't talk about the girls as children and youth. We often talk about them as women. And legally, we treat them as women if we are locking them up for prostitution, even though they are not of the age to consent. They are denied the legal status and protection of child. This adultification of black and brown girls is remarkably dangerous and is, again, playing out a long narrative, a historically entrenched narrative around the denial of child status that ought to be afforded to our children of color. So for me, the way that I have understood this work is very much from a human rights lens and a racial justice lens of being able to recognize that when our kids of color, when our girls of color are being bought and sold, that they deserve the right and the legal protection to be treated as children, which means that they have to be given all of the protections and supports that we understand from a human rights perspective of the right of the child. And it also is important to have a racial justice lens because there is a historical extension framework in the way that we talk about disproportionately Black and brown girls who are bought and sold as prostitutes and criminals and not victims and survivors of sexual violence. And as such, it's not only important to be able to understand that the girls who are bought and sold are children, are victims and survivors of sexual violence, that this exists in the context of abuse and violence and not vice and prostitution. It is also important to understand that there must be an end to the culture of impunity that protects the buyers who purchase girls. We are in this incredible moment right now, the Me Too movement, that I really see as the beginning of the end of the culture of impunity for sexual violence in this country. It is the beginning of a powerful undoing in the way that we have protected and supported and tolerated and legitimized abusers. And I see the need for the culture of impunity to also be dismantled in this space. That not only is it critical to contemplate, to understand, to treat girls who are being bought and sold as victims and survivors of sexual abuse, that they deserve the protected status of child, but that those who purchase their bodies be legally held accountable and no longer protected and tolerated and normalized in their desire to purchase a girl, a child, for sex. There is, without question, impunity for individuals who are buyers. We protect them by politely calling them Johns. We protect them by legally creating two separate worlds. There is a world in which if you have sex with an individual under the age of 16 or in some states 18, you have committed statutory rape or sexual abuse of a minor. Again, we recognize the legal protected status of child, the particular vulnerabilities of child. We understand the difference between the adolescent mind and body versus an adult in the context of statutory rape and sexual abuse of a minor. But all of that disappears when a 16-year-old girl is purchased. Rarely do we arrest buyers of children for anything more than solicitation misdemeanor. Even if that happens, even if an individual is arrested for the misdemeanor of solicitation, which is rare, there is rarely the attempt to go further and arrest and prosecute buyers of children for statutory rape, for sexual assault of a minor, for child endangerment. There is, throughout this country, a culture of impunity for the buying of underage girls and boys as well. But it is an extension of the impunity that is about sexual harassment, that is about sexual violence in this country. And in the same way that Me Too is finally speaking to and challenging the impunity of hurting our bodies, that too must be extended to those who purchase, who monetize our girls. And yet that is not happening. Instead, those individuals are rarely prosecuted. So we have created a difference between raping a child and paying to rape a child. And I think from a human rights perspective, from a gender equality perspective, from a racial justice perspective, because of who those girls usually are, that culture of impunity must end in the public square and in the legal context as well. And that, from a racial justice perspective, from a human rights perspective, from the right of a child perspective in human rights law, that we also have to contemplate within our culture and our courts that underage girls who are bought and sold must be afforded the status of victim and survivor of sexual violence and must be afforded the status of child, and that we have to understand what has played out historically in our systematic denial of that with our children who are disproportionately children of color who are trafficked. I also think it's really important to understand this from the place of criminal justice reform. So there's been a very powerful movement in the last 5 to 7 years around calling for justice reform in our country. Both Republicans and Democrats have really become united in many respects around understanding the brokenness of our criminal justice system. There has been a recognition that mass incarceration has only served to disproportionately harm and criminalize Black and brown communities and has not left our country any safer. But missing in a lot of this conversation around justice reform is the experience of girls. And so some of my work before I came on board at Google was to go to girls' detention centers, to be able to map out where are girls in the conversation around justice reform. And so while there was a powerful narrative being developed around the school to prison pipeline, it was clear that in mapping out the school to prison pipeline, it was mostly centered around the experiences of boys. And when I went to these detention centers for girls, what became very clear to me was that if you mapped out the experiences of girls and the juvenile justice system, it was really a pipeline from sexual victimization to that of criminalization, that we were criminalizing the ways that our girls were experiencing sexual violence. So what do I mean by that? So many of the girls that I met were there in detention for running away. But what were they running away from? They were running away because in foster care, they were being abused. In a group home, they were being abused. In their own homes, they were being abused. And so they ran to protect themselves. But in our criminal justice system, running away is a status offense for youth. And so we were criminalizing these girls for protecting themselves, and we continue to do that. We continue to make running away a status offense, and we continue to see the ways in which girls are disproportionately locked up for the status offense of running away. We tell women to run from their abusers, but when our girls run, we lock them up. But the other piece of what I started to understand was that we were also locking up girls for prostitution. And that the girls would talk about their experiences not as an experience of sexual violence, but as one in which they did something wrong, and that's why they were handcuffed, that's why they were put in the police car, and that's why they were serving time in detention. And so even though, again, they were not necessarily of age to consent, they were locked up on a prostitution charge or a prostitution-related charge. Upwards to 80% of girls who are in detention are victims and survivors of sexual violence. I had the opportunity to do a report with others called the Sexual Abuse to Prison Pipeline, The Girl's Story, because that is what I had learned in going to the detention centers and also in looking at the limited research that is available on girls, is that we see this criminalization of girls, and we ignore it. We don't include it in how we talk about the brokenness of our criminal justice system. So being able to understand that girls who are bought and sold and then criminalized are part of what's broken about our criminal justice system is critical. So in all the work that is being done around justice reform, we have to name that sexual abuse to prison pipeline. And those of us who are doing the anti-trafficking work have to do it from a racial justice lens as well, to understand that the criminalization of these girls for what they have been subject to is wrong, and is part of how we have to re-envision and reimagine our juvenile justice system. And when we talk about the school to prison pipeline, we also have to name the girls who are being bought and sold and criminalized and part of the sexual abuse to prison pipeline. All of that is how we name and reimagine our juvenile justice system. So I think there's real work that has to happen in connecting so much of the criminal justice reform work and that advocacy community with the anti-trafficking community and the gender equality work that is so integral. I want to be able to end on the note that there's often so much divisiveness that plays out on this issue, and I respect all the reasons for the divisiveness and the tensions and the disagreement. But there are also real places of connection, and I hope that when we talk about the undeniable issues of racial justice around what happens to our girls who are bought and sold in this country, when it comes to the right of the child that exists here within the US as much as it exists in our narrative internationally, and that when it comes to being able to understand that those who are bought and sold should not be criminalized, that there could be convergence there. And I'm interested in those places of convergence as opportunities to move forward. And I hope that in this moment where it is such a powerful reckoning that is happening around sexual violence, that we also name our girls who are at the razor's edge of gender-based violence in this country, whose bodies are monetized, and for whom, for so long, by virtue of being black or brown and female, you are construed as communal sexual property. Those realities in this moment also be named as part of how we insist on Me Too. So I'm going to wrap up with that. I have time for 2 questions and would love to talk about it. Yes?
I just wanted I just wanted to know how drug abuse plays a part in sexual abuse that's going on.
It's a really important question. There's certainly ways in which girls who are being bought and sold are also addicted as a way of enduring, right? There's a long reality of how, especially when you see substance abuse around women and girls, it's a way of self-medicating because of the violence done to them. I had the opportunity in the past to work around the meth crisis that preceded the opioid addiction. And it was unbelievable to me how many of the women who were using meth were survivors of sexual violence and used meth as a way to medicate to the trauma and violence done to them. So I think that there's always been this relationship to using as a way of being able to negotiate the trauma around existing abuse and previous abuse. And I think we see that around girls who are trafficked as well. And I think we see it in general around the issue of sexual violence and maternal addiction on the part of women and girls. Yeah. Yeah.
Thank you. I work in the domestic violence world with a number of the policies that have been fought for many years were really effective tools for certain populations and really almost tools of oppression for other populations. The example I'm thinking of is mandatory arrest,
right, where
certain communities felt that this was not the direction that they wanted to go. And I wondered if there are sort of clear preferences, policy preferences around how to work with how to intervene and change the direction of the sex industries from different race or ethnic groups.
No, I think it's a really important question, right? Because, and I struggle with this in terms of holding both the commitment to human rights and racial justice, because I don't believe in mass incarceration. I do believe in decriminalizing, right? And being able to speak to the ways in which we have so unequivocally and with such harm over-criminalized Black and brown communities. And at the same time, I don't believe in a culture of impunity, right? So those are often, sometimes those values work alongside one another, and sometimes they're in conflict. I think the example of what the domestic violence community has had to negotiate, right, in terms of being able to recognize we don't want a culture of impunity for abusing women, and we also don't want criminalization, especially criminalization that pivots only in the direction of Black and brown men. I think that's the same danger when we talk about ending the culture of impunity for buyers, right? I mean, we've seen that with traffickers, right? So there's no question that the way that traffickers are imaged is very much through repeating the predatory Black male imagery, right? So often when this community puts forward images of the trafficker, it reproduces the predatory Black male that is so dangerous to put out there that, we thought from the war on drugs, we learned how not to image Black men in a way that is so hurtful and demonizing, but it plays out in the way that traffickers are imaged. And it also plays out in terms of which traffickers are prosecuted. Who gets arrested, who gets prosecuted. I think it's very important that when we talk about the criminalization of those who buy our children, that we not only pivot in the direction disproportionately of Black and brown men. And what we know from the research also is that it's disproportionately white men. So I do think that those kinds of conversations have to happen in ways that they didn't happen until too late in the domestic violence community. And that we can't only lean on criminalization as a way of addressing this issue. And at the same time, I deeply oppose the protection of individuals who are committing acts of sexual violence against children. I'll do one more question.
Thank you, Malika. It was so wonderful to hear you. I work as a social worker for the Department of Children and Families, our child protection agency here in Massachusetts. And when you met with the girls, did they talk about best ways that social workers and people in this community could help them where they wanted to go? Obviously, I'm in full agreement with you that many of these girls don't belong in the facilities where you saw them. But did they talk about things that we could do to help them? Because I think their voice gets lost in all of this, and adults are talking for them, and we need to hear from them.
I think that's absolutely right, and I think that one of the most powerful things I've ever heard a child survivor say was, you guys have to be better than the traffickers, right? And so being able to create programs where it is not punitive, it is not regulating of our girls' bodies, right? Because the way in which girls feel punished for their sexuality is unacceptable, right? And so how do we create spaces where girls feel a place of power in who they are, where girls feel a safety, an absence of judgment, and an absence of punitive approaches. So, I'm very uncomfortable with lockdown approaches. I'm very uncomfortable with approaches that aren't solely in the public health space, because the moment we start moving into a space of criminalization of the girls, the trafficker has won. And I know that a lot of judges prefer to put girls behind bars because it pulls the girl away from the trafficker. But it might physically pull the girl away from the trafficker in that moment, but it pulls her closer emotionally to the trafficker, because of course she's going to feel shamed and further abused by a system that locks her up and tells her that she's the criminal. So how do we move this entire issue into a public health space? And that's why I think it's so important to be able to understand this as child sexual abuse. Because if we understand it as child sexual abuse, then we move it into a public health space. But as long as we keep it in the space of vice and prostitution, we keep it in a criminal space, and it doesn't belong there. And we'll continue to fail, and traffickers continue to win as long as that's where we are. Okay, thank you guys, I appreciate the time.
So I'd like to introduce our next speaker. It's Professor Emily Owens. She's an assistant professor of history at Brown University and works on the history of sexuality and slavery. Her current book project, Fantasies of Consent, Sex, Affect, and Commerce in 19th Century New Orleans, is a cultural and legal history of the sex trade in antebellum New Orleans. The project explores the lives of women of color who sold or were sold for sex in that market, as well as the legal, economic, and effective structures that determined much of their existence. Owens has received support from the Library Company of Philadelphia, the Charles Warren Center for American History, and the Mellon Mays Undergraduate Fellowship. In addition to her appointment in history, Owens also acts as a faculty fellow at the Center for the Study of Slavery and Justice. Welcome, Professor Owens.
Thank you. Before I begin, I want to start by thanking Professor Rothman and Dean Galeo and all of you for joining us today for this really important conversation. I've been really struck by the kind of breadth that we are hearing from today and the different kinds of perspectives that have been brought together, and I think it's a really unique kind of intellectual and policy-oriented space I'm really excited to be a part of. So my talk is titled Sexuality and Unfreedom and Historical Perspective, and the historical perspective that I bring is in some ways shaped by a kind of general sense of American history as it relates to sexuality, sexual violence, and the law, but also comes from the specific context of thinking about the intersection of sexual violence and sexual labor in U.S. slavery, focusing on Louisiana, but really kind of reaching into the antebellum South, so sort of 1800 to 1865 throughout the U.S. South. And I focus on sexual violence and sexual labor together because in that period, very much as in this period, the two things really track together. I don't think of sexual violence and sexual labor as the same. But the women in my study tend to experience sexual violence and sexual labor, sometimes at the same time, sometimes in different sorts of situations. And so I sort of track both at the same time, and also track the way that the law engages and thinks about both of those categories in the antebellum period. I was so struck by Malika Saar's sort of entry point into her really wonderful discussion, because her entry point is actually the same entry point that I take as a historian, the notion of the unrapeability of Black women. And so where her talk began with the kind of invocation of Black women's unrapeability because they are like prostitutes in the eyes of, mid-20th century white rapists, my project actually starts with the literal unrapeability of Black women in 19th century law. So in the context of US antebellum law, enslaved women were excluded from rights and protections in general, not all, not always, but most, and most of the time. But the particular exclusion that I'm interested in, and that sort of forms the root of my research, is the exclusion of enslaved women, and sort of Black women more generally, although that's a little harder to think through, from the category of rape. So rape is defined in the antebellum period in Louisiana as exclusively a white category, which means that enslaved women and other Black women were legally unrapeable, were legally outside of the category of rape law, which then has important consequences for their sexual lives, namely their capacity, or rather incapacity, to seek redress for any kind of sexual violence that occurred in their experience. And so I'm really very grateful that that kind of framework has been brought into the room before I've come here, and was just really struck that the kind of historical specificity of the legal exclusion of Black women from rape law lives on in these kind of cultural legacies, right? So by 1960, Black women are not, in fact, legally excluded from the capacity to give or withhold consent, and yet in practice, in terms of a culture of sex and in terms of a legal culture of enforcing sexual norms, they remain outside of that category. And so my research sort of begins to unpack how we got there, how we got here. I'm not really going to talk actually about rape law, however, or not that much today. I'm going to talk briefly about the framework of my research, which I think is, I hope, the more useful side of what I do for the kind of policy-oriented conversation that we're having today. I'm going to tell a few stories briefly, and then hopefully try to suggest some ways that I think my research and the kind of history of sexuality in the US might come to bear on the contemporary questions that we have and that we're dealing with today around sort of cultures of sex and money. So my project is both a legal history and an intellectual history. I'm interested in the ways that the law shaped, and especially the racialized ways, as I just discussed, the sexual culture in the antebellum period. And I'm interested in the ideas that people used then and that people use now to describe sexual culture. So I'm really interested in the frameworks for many discussions about sex, violence, labor, and money that come up in historical studies and sort of frame historical studies of sex and sexual violence and sexual labor in the past, and I think really remain with us as kind of underwriting principles that shape the conversation that we're having today. So I'm interested in basically the thing that many of us have invoked as we've come up to the lectern, which is that the notion of selling sex is controversial, or it's a hot topic, or it's something that people have strong feelings about. And I think that the reason, or at least part of the reason, that those strong feelings exist about sex and labor has to do with four categories that I think underwrite the conversation, and they certainly underwrite the conversation when we're talking about the history of sex and labor in the US. Those categories are rape, consent, which often gets, I think, sort of smushed into choice or used interchangeably with choice. So rape, consent or choice, slavery, and freedom. And I think that those 4 terms tend to represent the poles of debate around sex and labor. So I'm going to talk a little bit about kind of what my research reveals about those categories. We tend to think, and I think it's sort of like an underlying part of our discourse around sex, our contemporary feminist discourse around sex, that if we want to know if sex was or is in the past or in the present good or okay or legal, we tend to measure how voluntary the sex was, how free it was, and how chosen it was. And those terms, voluntary, free, chosen, and other sort of aligned terms tend to track together in our association of something about sex being okay. If we want to know if sex was bad, was not okay, and importantly, was illegal, we measure how involuntary it was, how close it came to what we think of as rape, which of course itself is a historically changing category. The definition of rape was different, 20 years ago. It was a lot different 150 years ago. So that category changes, but we tend to measure whether or not sex was legal or illegal, or how illegal it was, relative to what we tend to as a society agree is definitely not legal, which is rape, and how close we think that scenario came to slavery, which is to say a lack of choice, either legally prescribed or not. I think money is really interesting here and complicates all 4 of these terms. In the 19th century, jurists tended to agree that money could buy consent. And although that's not a sort of presupposition of contemporary law, I think that that notion of kind of transaction as complicating what choice is or isn't present in a sexual interaction remains with us. So I think that we see vestiges of this notion that money could buy consent in our contemporary understandings of sexual labor and sexual transactions. Not so much in spaces devoted to thinking about sex work, but in the extent to which it remains almost impossible and certainly difficult, as now as it was in the 19th century, for a sex worker to get a conviction for rape in court. So even though, and I'll talk more about this in a second, all women in the United States are entitled to the right to withhold their consent to sex, in practice, lots of women actually can't make that real in court, and sex workers are at the top of that list. So if a major guiding question for today's conversation is basically, should it be legal to exchange sex for money, my research scales that question back a bit to ask, how does money shape sex? So if we want to understand the should, I want to understand the how. Also, to the extent that money can buy consent, which is sort of an oxymoron anyway, because consent is supposed to be, at least in the legal framework of the U.S. Constitution and the sort of British law that preceded it, it's supposed to be freely given, and therefore is not supposed to have a price. But anyway, to the extent that money can or could buy consent, it returns us to the question of freedom. Essentially, does the presence of a financial transaction make sex more free or less free? Does the presence of a financial transaction represent a contract in which money represents the presence of 2 equal, that is, consenting parties who have agreed to something? Or does the presence of money mean basically the presence of coercion, money representing the giving up of something, perhaps giving up everything in terms of the sovereignty that she might have over her own body, or the sovereignty that she might have over her own body during the temporary period or whatever period has been designated as being paid for underneath that contract. And I think all of these theoretical questions get thrown into relief in the context of what I study, thinking about the past and thinking about US slavery, because the women that I write about were for the most part legally and literally unfree. They were enslaved. And so that's a really important distinction, I think. When we talk about slavery and unfreedom in the contemporary context, we are not at least in the US context, talking about people who are legally on the books, supposed to be allowed to be enslaved. And that's not to draw necessarily an important distinction between conditions, although it is perhaps to do so. But I do think that the literal and legal unfreedom of the women that I write about throws into relief some of the questions that we are kind of discussing for the contemporary period. The women who I write about still lived in a situation in which their ability to control or be autonomous over their material lives was basically null and void. And so that, I think, kind of shapes my comments here. And then in my research, the simultaneous presence of sex and money tends to be complicated. So in the context of this like fundamental landscape of unfreedom for Black women, what I have seen in my research about sex and money is that those situations in which sex and money combine represent both routes to freedom and routes to unfreedom. And I'm going to try to suss out what I mean by freedom in a minute, but I'm trying to grapple with that, the ways in which sexual transactions can be avenues out and avenues in. So ultimately, my finding is that these categories, these poles of debate that are supposed to tell us something definitive about what sex should happen or should not happen, are often more helpful, more confining than helpful for understanding the lives of the women that I write about. So I'm interested in sort of three questions. One is, what categories currently shape our conversation about sex and money or sex and work? And I've named the four that I think shape it, but I don't think that's definitive. The second question is, what is the meaning of those categories? And that's where things get really sticky. I think if we polled, 5 or 6 people in this room and asked them to define choice, we would get probably 5 or 6 different answers. And they would all belong probably to a similar world, and yet they would not be the same. And so I think that kind of use of jargon around these questions may be challenging us around trying to understand what we're talking about. So the third question then is, what is the capacity of those categories to actually describe what we see, what we're talking about? And what I found in my research is that the 4 categories that I invoked at the beginning tend not to be very useful for me in describing what I see in my archive. This is not to say that I want to throw those categories out. So I work on the past, and the people who I work on are long dead. And the sort of investigations that I do in the past have led me to a great suspicion of the category of consent as something that is legally useful for protecting Black women or women generally. That said, the context that I work on is legally very distinct from the one that we live in many ways. Not always, but many ways. Which means that in the present context, consent is in fact not just legally accessible, but legally kind of ironclad for all women, at least in theory, and certainly as it's written in the law, to women in the United States. And so it's one of the few tools we've got with which to combat sexual violence. So I'm not suggesting that we sort of throw the baby out with the bathwater, but I am suggesting that this history might help us kind of ventilate the conversation in these binaries a little bit. And I think that going into the past and getting sort of far away from the really complex realities that we are living in and entering those really complex realities can help us get a different sort of perspective and double back onto the present with a different kind of vision. So what I'm sort of moving toward in my research is, if those categories, if I'm arguing that these categories are sort of insufficient or don't tell us enough about what I see, what I want to try to move toward is a description of materiality. So rather than saying that person was free, that person was unfree, that situation was slavery, that situation was rape, that situation was good sex, that situation was bad sex, I'm much more interested in thinking about material conditions that people were living in and that their sexual lives took place within. I'm also interested in descriptions of structural inequality that shape those material conditions, because I think particularly the question of consent, which is at the heart of my research, really loses meaning in the context of fundamental structural inequality and constant violence. And so I'm also interested in engaging with sort of our historic preoccupations and our historic discomforts around sex and work. historically, people have been concerned about sexual labor as sort of the symbolic pinnacle of everything that's wrong with society. And you see this in all kinds of political economic theory that's written in the 19th century. But my suspicion is that that kind of like bemoaning of sex work as the worst thing ever is often a performance, and usually that sort of affective stuff around bemoaning or disavowing sexual labor becomes a way that allows us to remain comfortable with other kinds of gender inequalities. And so finally, my research makes race not ignorable. Categories like consent and freedom take on different meaning when we think about histories of blackness and whiteness in the US. And I think that those racial differences in the past absolutely shape the kinds of racial differences that we see in terms of the kinds of sexual cultures that women are a part of in the present. Okay, so I'm going to talk a little bit about the women that I write about. So all of slavery was sexualized. But I write about actual sex. One of the central questions, and what does that mean? That's also a question. But anyway, one of the central questions that I'm trying to understand is how historical actors understood a concept like consent, but also what the experience of violence was in a context of a world in which ubiquitous sexual violence was everywhere, and in which violence that contemporary people like us would qualify as sexual violence, i.e. forceful penetration or touching of particular areas of the body, was actually everywhere and could happen basically at any time to enslaved or free black women, and to many white women as well, and in which the kind of bodily interaction that was central to the project of slavery, also touching, also poking, also prodding, also bodily display, was a very normal part of everyday life if you were sort of walking down the street in New Orleans, which is the city that I focus on. So to be clear about what I'm talking about, sort of what was the antebellum sex trade, I'm going to describe a couple of different scenarios that come up in my research. My research sort of thinks about basically 4 types of women who were involved in some way in the world of sexual labor. And what I'm going to do is kind of give you a typology, although it's important to remember that these categories were really not fixed, but in fact, women tended to move from one type of labor to another. They might have begun their life as enslaved and ended up free. They might have begun their life legally free and ended up enslaved. And actually, that's part of the challenge here is trying to think about what those categories mean when the material conditions may or may not change very much at all. But so the categories that I'm talking about are not defined by distinctions of slavery and freedom, are fairly fluid. So here are 4 examples of women who are in my study. So Celia was actually in Missouri. She was not in she didn't live in Louisiana. But she's sort of emblematic of a particular kind of enslaved woman who was purchased as a worker on a plantation by a slaveholder, but was used for sex. So sex was not her job. Agricultural work was her job. But she experienced forced sex with the man who owned her on basically a daily basis. And there are lots and lots of women that we know about who sort of appear as tangential characters in lots of slave narratives and other kinds of sources in which sort of daily forced sex was a part of their existence, although was not sort of their primary thing that they had been purchased to do. I understand that the sex that she experienced I understand the sex that she experienced as labor, but under the laws of the time, because under the laws of the time, enslaved women's sexual bodies, like any other part of their bodies, was the property of the slaveholder, and their property was used for the purposes of labor. Importantly, Celia's life was structured by the racialized nature of rape law, which is what I invoked before. Rape law at that time stated that rape was a crime when enacted on the body of, quote, any white woman or girl, meaning that any kind of sexual interaction with a black woman was permitted by law, in fact invited by the law, I think, and meaning that there was no legal mode for redress that existed for black women who were forced into sex. Celia eventually killed the man who owned her, and then was convicted of first-degree murder and hanged by the court. So for Celia, sexual labor was the heart of her torture, and she was really clear about that. And obviously in her action of killing the guy who owned her, but also comes out in the court record. It was the root to her unfreedom. Her unfreedom pre-existed the sexual labor, and yet it deepened the unfreedom. It was the defining aspect of the hardest part of her material existence. Okay, so that's Celia. Alexina. Alexina was purchased at a young age, probably 11 or 12, to become the fancy girl of a slave trader. So fancy girls were women who were purchased specifically for sex. So unlike Celia, for whom sex and sexual violence was sort of incidental in the mind of the person who owned her to the other labor that she was doing, Alexina was purchased for sex. That was her job. So the qualities of her body were understood to be an important part of her labor, like most enslaved people. Her body, in particular, like others like her, she was light-skinned, she had blue eyes, she had blonde hair. She was so light, ultimately, that she sued for her freedom on the grounds that she was too white to be a slave, which is how we know about her. She came into the record as a housekeeper, so as many fancy girls did. So she was enslaved and therefore had no legal rights to her body or to her sexuality, and her work was sex. For Alexina, sex had became an emblem of her unfreedom. It was the work that defined her enslavement. But as the trial played out, it was kind of unclear to jurors if the sex work she was doing made her more like a white woman, but more like a prostitute, which was the language that they would have used at the time, and therefore would have created an avenue toward freedom, would have bolstered her argument that in fact she was white and should not be enslaved, or if it made her more like a black woman and therefore sort of centralized and codified her relationship to slavery. We don't know what happened to Alexina Morrison because her case was interrupted by the Civil War. So presumably she got free unless she was killed during the war. Okay, Carmelite. Carmelite was an enslaved woman who worked in a brothel. A large portion of the city of New Orleans, the urban metropolis at the heart of the US slave trade in the 19th century, was devoted to brothels. The brothel that Carmelite worked in was owned by a merchant who sold, a white merchant, who sold various items like clothes and buttons and mechanical objects, and who also sold sex in the context of this brothel. She performed sex work in the brothel, but reaped none of the financial reward. We don't know about the particular structure of her workplace, but based on some clues that we have from her case record and from other scenarios, it's likely that she worked beside other enslaved women, free women of color, and white women, and that another enslaved woman was probably tasked with collecting the fees that she earned on her behalf and then handing them up to Jean Lacaze, who was the guy who owned the brothel. Importantly, Carmelite worked on a contract. She was considered legally a statut liber, so not a slave, not a free person. A statut liber in Louisiana at that time was someone whose freedom was imminent because of a law that said that if she worked in a brothel for 7 years, she would earn her freedom. She did work for 7 years in the brothel. Lacaze tried not to free her. She went to court to sue him. That's how we know about her. So not all women in brothels had the kind of deal that she had. Not all enslaved women had this kind of deal. But surely many did because a law existed to regulate this practice. And also Carmelite, I think it's important to note, got into this situation because she was enslaved, obviously, but also because she had been a nursemaid or like a wet nurse. And the woman whose child she took care of was so grateful that she had taken such nice care of her child that she basically put her in the brothel as a favor. And that's what she sort of says in the court record. It's like, I thought this would be a good scene for her because it looked like a route to freedom. So for Carmelite, sex and sexual labor became the route to her freedom, or was imagined as such by the person who placed her in the brothel. But ultimately, it became the site of her unfreedom, and it was basically the reason she couldn't get free, because in the court record, there's a big battle about whether or not she had misbehaved. If the sex work had been a site of misbehavior, that would nullify her ability to get free. So, again. Okay, the final story that I'm going to tell is the story of Anne Maria Barclay. Anne Maria Barclay was a concubine, and so concubinage was the legal term used in the 19th century to describe people who cohabitated but were not married. Cohabitated in a sexual relationship, but were not married. She began her life as an enslaved woman who was purchased as a housekeeper for George Ann Botts around age 14. Shortly after purchase, he sent her to Ohio, a free state, where she received her free papers. She then returned to New Orleans with free papers in hand and moved back in with him. She lived with him until he died, and their arrangement was understood to be living, in the record it says, as his wife. By many in the neighborhood, despite the fact that they were not and legally could not be married, despite the fact that this, as a woman of color, she retained no legal rights really to basically anything that they were doing, so owning property, owning other enslaved people, et cetera. So she gained her freedom legally, but then also her freedom was underwritten by a law that said that people whose owners let them live like they were free people for a certain amount of time sort of became free. So that's freedom by prescription. Even so, she spent years in court defending her freedom. So there are two ways in which the law says, okay, Anne Maria, you're free, and yet she still has to go to court to defend her freedom when Botts dies, because really his existence and their kind of cohabitation arrangement was the key to her maintaining her freedom. So she's really the most illuminating person for me, because through sexual labor, she got legally free, not just sort of in theory free, but she came back. She came back to New Orleans, the heart of the slave trade. So for Barclay, sex work became the route to her literal legal freedom, but that freedom could not be made real in a material sense without the ongoing support of the man who had previously owned her. If she had been alone in a new place, didn't speak the language, didn't have connections to white people especially, she would have been in trouble. So the transactions in these situations are all really different, but what I'm trying to ask is, where's the freedom? Who is more free? Whose experience is more violent? Where is the rape? Where is the contract? Who is consenting and why? And we have to remember, of course, that black women don't legally gain the right to consent until after the Civil War. So I'm going to finish up by asking a couple of questions. I think that these scenarios return us, as I just invoked, to the question of what do we mean by freedom? We cannot have conversations about sex and money in isolation. Sex meets money, I think, often and usually because of because of structural inequality, and sex meets money in danger. And I think the danger is the thing that most of us are really concerned about here, because of structural inequality. That is most apparent in slavery because but it persists now. These women were involved in sex work because the legal landscape they were a part of made choice essentially a ridiculous idea. So I'm interested in thinking about the material conditions that they lived in. Where was the violence? When did it happen? Where was the danger? Where was the threat? Where was the pleasure? Where was the access? Where were the resources? Where was the mobility? Where was belonging? Where was community? I think that those are better metrics for understanding what was going on in their lives than categories, big categories like slavery and freedom. I want to know about their living conditions. I want to know what shaped them. And also, I think we should remember that, at least in their context, violence was everywhere. So it's not just violence was present on the plantation or violence was present in the house of the slaveholder. Violence was on the street, violence was in the yard, violence was everywhere. So how do we understand what choice might have looked like in that kind of a scenario? Second, my research, I think, calls us to think about the multiple formations of gendered relations as transactional. So for the purposes of the law, anyway, marriage is on the same spectrum as concubinage and brothel labor. They're not the same. The material conditions that attend to them are not the same, and were not then. But legally, at least in terms of their origin story, they're all about trading stuff for women's bodies, an exchange between men, and an exchange between men that uses choice or consent of the woman as its alibi. So in the context of 19th century marriage, consent was required. The woman's consent was required to codify the marriage in Louisiana, but of course, once the consent had been given, that was it. She had consented to everything and anything that would happen going forward for the rest of her life. And so consent there becomes much more of an alibi for violence than anything else. Third, my research calls us to think about varieties of intimate labor because they were linked up in the historical sex trade and they remain linked up today. We tend to be troubled or feel that it's controversial to think about sex and money. But I'm interested in the other kinds of bodily and affective transactions that surround us. And I think that that current scholarship on contemporary sex work really calls us to think about this. The girlfriend scenario, the sugar baby scenario, right? All of the other kinds of intimate and affective labor that happens in the sex trade makes us think, I think, about other kinds of intimate labor that we seem less troubled by, that seem more more normal and less controversial. I'm thinking about the rise of the sharing of breast milk and wet nursing, also the sharing or the selling of sperm or blood, thinking about surrogacy, which has seen a major rise in terms of reproductive technology in the last 20 years. But also, those are more obviously contentious issues. We might also think about domestic labor. We might think about nannying and care work and the loving of other people's children, both of which I think come with sort of similarly dangerous or sometimes similarly dangerous histories around labor conditions in intimate scenarios. I also am really interested in therapy, which is sort of our American obsession, right? And the sort of the ways in which we feel really comfortable paying people to care for us, to talk to us, to process with us our most intimate desires, fears, and anxieties. Finally, the last thing that I think about in the context of my, my research as it relates to the presence is just about the law. And to the question of decriminalization or legalization, it's not something that I know enough about in the present to really comment on, but I think that the past is instructive. When you think about Black women in the context of the 19th century who are written out of the law, what we see is that being unrecognized by the law makes you more vulnerable, not less. And I think that being illegal, similarly, whether we're talking about sort of national status or we're talking about performing something that is considered a crime, means that it becomes more difficult to seek redress. And it means more vulnerability, not less. So I will end there, and thank you all for listening. Okay, so I have a time for a couple of questions.
Hi, thank you. That was so illuminating.
Thank you.
A couple of months ago, I was in a room with a bunch of sex workers of color, sex workers by choice of color, of a variety of, some of them were dominatrixes, some of them were escorts. And they all, someone said, a client asked me for this slavery fantasy where you're the slave and I'm the master, and often in a dominatrix context where the woman is the person in power in that situation. And then every other Black woman in the room said, oh my God, me too, so many times, particularly the man asking the woman to use the N-word and stuff like that. Being white and not having encountered that before, I was like really mystified. And I wonder if you have any thoughts about like the origin of that sociologically, culturally.
Well, sort of. So I have two thoughts that are maybe related, but I don't think that they're totally, I don't want to trace an origin story of that context, because I don't think I understand it fully. But I do think that in the sexual, I think that someone said earlier that sex is about power, or that sexual violence is about power. That sexual violence is about power, that's what it was. And I think sex in general is about power, often, maybe not always. In the context that I study, the violence is real, and the legal violence is real, and structural violence is real, and much of that violence persists into the present. But I also think, and a lot of what I write about is sort of like, where is the desire for slaveholders to purchase sex from Black women when they can take that sex legally? Why would they purchase it? So I think that the question of desire and performance is present in the 19th century as well. I think it's a different set of questions for the contemporary. I don't know very much about sort of like BDSM and sex and power in the present and those kind of labors and performances. But I do think there are two well, maybe one scholar whose work I find really instructive in this. And that's the work of Jennifer Nash, who writes about pornography, race and pornography. And she's said some really interesting things about the ways that in the contemporary setting, she's thinking about pornography as a visual technology, so she's not thinking about the material conditions that are behind the production of pornography, but she is really interested in thinking about what she calls race play, and the ways that, all kinds of things shape our sexual desires in the present. And she sort of suggests that those things are challenging and complicated and morally charged, but also not simply morally charged, right? That kind of scene that you're describing might be a scene of violence toward that woman, might be a scene in which the black woman in the space is saying, this is horrible and I don't want to do this. And it might be a scene that's pleasurable and weird and interesting for her, right? And so I think opening that up in a contemporary setting, at least in the context in which, like, I don't know how we define violence, but thinking about violence is not like a pressing or urgent concern or fear or threat in that moment. I think it's a really interesting and weird scenario, and I think that our sexual desires tend to be interesting and weird.
Thank you. That was such a fascinating talk. And I was curious, with the use or discussions about slavery and discussions about freedom, a lot of times now the concepts of human trafficking have been really conflated with the ideas of slavery and, you know, the evolution of modern slavery and coming through the language of white slavery. I was wondering if you saw that relationship as productive or as, and I guess I'll just out myself of how I see it, but kind of as a deracialization of the relationship between slavery and dehumanizing bodies of color when it becomes conflated in the way of exclusively talking about it in terms of a labor-based exploitation.
Yeah, so I think that the sort of modern day slavery framework is problematic in, I think, more ways than it's useful, but I don't know enough about the ways that it's useful to really comment on that. But yeah, I do think that there's a way that, as you say, the kind of invocation of modern day slavery might take race away from the kind of notion of Atlantic slavery. I do think it simultaneously invokes a kind of framework of Atlantic slavery as the only slavery, which it was not, is not. But so it's not so much for me about like slavery belongs to black people and or black American people or black America's people, and it doesn't belong to anybody else, and it's not a useful framework. I think we need to better understand what we mean when we say slavery. When I say slavery, I'm talking about US slavery in which the category of slave and the category of free person are written into the law, and when you are born as either a slave or a free person, and changing your status is really hard. So for me, it's much more about the kind of legal structure behind the word, and that makes sense because I'm a legal historian. But I think lots of people think about the word slavery in different ways, and there might be utility to thinking about other forms of unfreedom other than kind of legal unfreedom, and using that word to describe those situations. But yeah, for me, when I use the word slavery, I'm talking about Atlantic slavery, and I'm talking about a particular system of legal and hereditary enslavement. But again, historians of slavery know that slavery has happened forever and will probably happen forever. But historians of US slavery or Atlantic slavery think about this very particular context. And so, my impression is that the invocation of kind of modern day slavery tends to invoke Atlantic slavery. And so in that way, I think there's trouble. But if modern day slavery is thinking about a global and sort of constant transhistorical framing of some people being more free than others, then it is very descriptive. I don't know even if we have time for one more question. I think we're good. Yeah. Thank you.
Great. So thank you to all of our speakers who have presented thus far. So we're going to do a slight adaptation of our schedule. We're actually going to break for lunch now. It's 12 o'clock, and we're going to reconvene with our next speaker, Audrey Morrissey, at 12:30. But before we break for lunch, I wanted to invite you to browse at our registration table a chapter that's been provided by an author who's here, Kate D'Adamo. And she's also a writer and thinker on some of these issues and has made available her work. So please feel free to check that out if you are interested. The lunch is excellent. And I hope that you will return and be here at 12:30. Thank you.